I'm Melissa Mancini with Canadian HR Reporter TV. I recently sat down with Megan Burkett, a lawyer at Kaiser Mason Ball's Human Resource Law Group. We talked about what's important to include in an employee handbook.
I've been reviewing handbooks for a number of years, and I see the same mistakes over and over again. So the first type of mistake would be where your policy is conflicting with the legislation. That could be for two reasons. One, your policy or your employee handbook is out of date, your policies are out of date. And the second is it could be US based. So either the company has a head office in the US and they've asked the company here to implement it and no changes have been made, or someone's been finding policies online and not realizing that, hey, these are US concepts. If it's referring to at-will employment, if there's an extensive drug and alcohol testing policy with zero tolerance and no accommodation, I mean, those are things that are not recognized in Canada, and you do not want those in your policies. Conflicting versions of employee handbooks, a lot of times companies will keep the old versions out there and they'll change the new handbook. I mean, you need to get those new versions out there. You need to get them to employees. You need to follow the same process of implementing it properly, having them sign an acknowledgement form. If you're going to all this trouble, you might as well make sure you've done things properly so that you can rely on your policy. So depending on the policy, there's language that I usually recommend. So probationary period, that's one example where, yes, it's covered in the Employment Standards Act, but what people don't realize is in the first 3 months of employment, no payments are required under the Employment Standards Act, but there could be payments owing under common law, or there could be, you could have where you've extended the probationary period. Now you're outside of that, or you may have a 6-month probationary period. So you want to have language saying, if we terminate your employment during the probationary period, you'll receive the minimums under the Employment Standards Act. So if it's less than 3 months, the minimums are nothing. If it's between 3 and 6 months, they're 1 week. So you want language to protect yourself to deal with those other types of situations. So temporary layoff is another one where, yes, it's in the Employment Standards Act, but there's a lot of case law on that where the courts have said, no, you cannot put a manager or a supervisor on a temporary layoff. Or you have these groups of employees that you've never laid off before, they never realized they could be laid off. Just because it's in the Employment Standards Act doesn't mean you can do it. We consider that to be constructive dismissal. So making sure you have a policy that covers that. Overtime is a big one. If you're going to have an overtime policy, when is it triggered after an employee works? Is it daily overtime? Is it weekly overtime? The Employment Standards Act only talks about weekly overtime. As well, who does the policy apply to? If you don't mention anything, then does it apply to everyone? Does it apply to your managers? So you want to specify, what groups of employees are excluded from that policy. It ends up being a large document that employees have to look through. So while you should be giving them a copy, either a paper copy or by email, you also want to have copies available around the workplace. Even if you have an intranet site, have copies available for them, because a lot of times employees will say, well, I know there's a policy, but I don't really know where it is or how to find it. As well, have a meeting. Have an opportunity for employees to come together, present on some of the key policies, giving them time to ask questions, giving them time at work to review the handbook. Finally, getting an acknowledgement form. That's key, because you want them to sign off on a document saying, yes, I've read it, I've had a chance to review it, I understand, I've asked questions. That way you can prove that they actually read the handbook and received a copy. So not only initially when they first start with the company should they sign an acknowledgement form, but they should be signing an acknowledgement form whenever you're introducing a new version of the handbook if you've added policies. As a lawyer, when you end up in court and it's a just cause case and you're trying to say, yes, the employee was aware of all these policies, that's one way. It's a document you can show to say they knew about the handbook.